Hello everyone, myself Madhuri, Associate Professor, Department of Law, Padmavati University. Today we want to see about capacity to contracts under contracts law. When we want to talk about a capacity to the contract, Section 11 of Indian Contract Act describes particular form. Every person is competent to contract who is in the age of majority according to the law to which he is subjected and who is of sound mind and has not been disqualified from contracting by or any law to which he is subject. So we have three main aspects we can say: being a sound mind, attaining the age of majority, not disqualified from entering into a contract by any law. A contract made with a minor is absolutely void since a person less than 18 years of age does not have the capacity to the contract. Any agreement made with the minor is void ab initio from the beginning. For example, 17 years boy or 6 months also cannot be taken as a friends or something, and liability or the loan also we cannot make it out. The court agrees and relieves Peter on the same way. Also, if a minor enters into a particular contract, then he cannot ratify himself. He attains the majority since the contract is void ab initio. And person of unsound mind, according to Section 12 of Indian Contract Act 1872, for the purpose of entering into a contract, a person is said to be sound mind if is capable of understanding contracts and being able to access its effects upon his interest. It is important to note that person who is usually of the unsound mind but occasionally of the sound mind, he can enter into a contract when he is in the sound mind. No person can enter into a contract when he is unsound mind, even if he is so temporarily. Disqualified persons also will be taking, apart from the minors and people with unsound mind, there are other people who cannot enter into a contract. That means they do not have the capacity to contract. The reason for the disqualification can include political status, legal status, etc. And some such persons like foreign sovereigns and ambassadors, enemies or convicts, insolvents also can be included in this. And other part you can see is the free consent. In the free consent you can see Section 13 speaks about this: coercion, fraud, undue influence, misrepresentation and mistake. So identity of mind is nothing but free consent we can say. An agreement is said to be valid when it is the result of free consent of all parties. In order to the valid contracts it made, an agreement should reflect the real intention of the parties. But in many cases the apparent agreement may not be in fact real agreement between the parties. So why free consent is very important? The particular reason is this: two or more persons are said to consent when they agree upon same thing in the same sense. Without it, contract cannot be voidable or void. So free consent is absolutely essential. Consent is said to be free consent if it is not caused by undue influence, coercion, fraud or a misrepresentation. Committing or threatening committing an act which has been forbidden under IPC, that is Indian Penal Code, one person is able to dominate the will of other person for unfair advantage comes under undue influence. And the fraud means when one person makes a misrepresentation, knows it is false. If you want to talk about misrepresentation, when one person makes a misstatement of fact which he believes to be true. Mistake means erroneous belief about something comes under this category. Coercion always stands for the one person forces other person enter into a contract by using this violence, intimations or something undue pressure, for their undue pressure. If the contract is formed under the particular coercion, it is voidable at the coercion parties. And undue influence, if you want to talk, a place when one party has a significant power of influence over the other party, leading the weaker party's inability to exercise independent judgment. Fraud always involves deliberate misrepresentation of facts of or the concealments of materials information with the intention to deceive other parties. To constitute fraud, a false representation of a fact, knowledge that the representation is false, an intention to deceive, reliance by the innocent parties or on the false representation and so on. Misrepresentation stands on the nakkas of the false statement which has been made on innocently, that is an intention to deceive them, or negligently without due care and induce the other party to enter into a contract. Mistake is an invalid contract. It is bilateral and both the parties have a making a mistake, and regarding that one is a fundamental aspect of a contract. Mutual, both the parties mistaken about the same fact, or one party is mistaken, other party knows and ought to have known about the mistake. In such cases, the contract may be void by the mistaken parties. Immoral or illegal practices or the contracts can be comes under illegal activities or go against public policies or generally considering themselves is void. For example, contracts related to illegal drugs or contracts under promote criminal activities comes under this category. Finally, free consent to an agreement has the utmost importance. It is based on the concept of conscience and at the same time it protects the interest of the parties to your contract. It reduces the impact of fraud, misrepresentation, coercion and undue power of the parties in the contract. When the contract is made out of free consent, it is both valid and enforceable by the law. Thank you.